The Honorable Chief Justice and Associate Justices of the Supreme Court.
The House will come to order.
The Senate will come to order.
Welcome to the committee.
Thank you, Mr. Chair and members, and I will keep my comments short. I think many of us have more of a lack of information on judiciary, and that's why we have really strong feelings on that incumbency designation or things that maybe hinder people from getting information on how judges rule or people that are running for that office. And having been serving here 9 years and before that 4 years as a mayor, we always hear these different issues from our constituents, and I've heard many issues about judges and cases. And people always tell me that when they feel just this empty feeling when a judge rules something and they disagree with it, but maybe don't have the money or the wherewithal to bring it somewhere else. And I'll just start with one simple case that I went through in district court. I won't give you the details, but the judge's ruling was exactly this. As she faced me and my attorney in district court, she said, "I find no basis in law," and that's her quote, "I find no basis in law, however, I feel as though the plaintiff has been aggrieved." And to me, you don't have to be much of a student of the law to understand that a judge takes an oath of office like we do as legislators, and if you blatantly say you're not using the law as part of your decision, I think you ought to be removed. And I've heard of many folks that have come to me and said, well, we've put complaints before the Judicial Standards Board, but these are judges that are and attorneys that are judging their peers, and so they have this tendency to not want to make an adverse decision on their peers. And I think that's normal. I think we as legislators, at least I don't want to make any harsh judgment about my peers, whether I disagree with them or not. I always try to find the good in everything, and I think that you need somebody outside to be able to judge when something's going wrong that way. And I think you need a better set of rules. The Supreme Court has come up with rules by which we they have this Board on Judicial Standards and the rules by which we judge our judges. But I'm the chief author of a bill. We don't have the Senate version yet, but the House file is 1568. And we're looking at modifying the structure of the membership of the board by replacing the existing membership of the board with 8 legislators, 4 from each House and the Senate. So members, currently the board consists of 1 Court of Appeals judge, 3 district court judges, 2 lawyers, and 4 non-lawyer citizens. So you do have citizens there. But I think it's hard for that citizen then again to grasp, and I don't meet that many people that read the Constitution. However, I'm always there to provide them a copy of both the Minnesota and the U.S. Constitution so that they can read it and understand it. So I think in order to understand a complaint, I think we as legislators perhaps have a better grasp of that. And maybe I'm not so certain that that's the right makeup, but I think you need to start somewhere to change from really the attitude of the citizens that the fox is watching the hen house. So the bill doesn't specify how the members of the board would be appointed, so there's a lot of work that we can do there. It also modifies the powers and authority of the Board of Judicial Standards, and it clarifies that a board may remove or retire a judge directly, and it also permits a judge to be suspended from office for a conviction or guilty or no contest plea for any crime. Right now, a judge can only be suspended for a felony level offense or a crime involving moral turpitude, which gets to be a little fuzzy as to how people might judge that. But again, maybe it's just that I have a hardcore opinion that when a judge stands before me and says I find no basis in law, I'm envisioning that somehow after taking the oath of office, little gremlins should come out of the back room and grab that judge and haul that judge away. That is just not what they're supposed to do. They're not supposed to make a ruling based on a feeling. They're supposed to make it based on law. If they can make a ruling not based on law, then why do we need a legislator? Why would we need anybody in the legislature? Why would we need governors that says that the judiciary is the one hand of government and the only hand of government. So members, we need to change something, and we need to have a way to make certain that judges are doing what their job is.
Mr. Chairman and committee members, I'm Paul Willett, now retired, fortunately, former trial lawyer and judge and all that sort of thing. And I was with the Board of Judicial Standards as its executive secretary for 5.5 or 6 years. The reason I'm here today is I was asked to review the history of the development of the board.
Judge, would you pull the microphone closer to you?
Surely.
It's,
Is that better?
we don't always magnify the sound. The microphone is used for the public record, so we'll ask you to speak just a little louder.
I'll do my best, and if I'm not, yell at me.
I wouldn't yell at you, Judge.
Before I get into the history itself, there are, I think, 4 things that people who deal with judges in terms of their conduct and decisions is, first of all, there has to be a distinction between function. In other words, the person who is investigating something or who is acting as a judge, the legislator represents the constituency of people who have specific desires in terms of policy and construction. A judge's job is to judge. And the 2 functions are quite different, and I think they have to be kept in mind when dealing with the code and the rules for discipline. Having said that, the goal of having an independent judiciary is to protect the public. So we have a difference in function, and we have a different in end goal. So all of the things I'm going to talk about today, it would be helpful, I think, in understanding them to keep in mind this distinction. And I think the role of the judge, I couldn't say better than the first canon of the code, and I'm going to read that. A judge shall uphold and promote the independence, integrity, and impartiality of the judiciary, and shall avoid improprieties and appearance of improprieties. That's a very high standard. And I think it's, again, getting back to the function of a legislator or the public opposing the board members, it makes a difference. I thought I would start out by, I hope you have the material from the Minnesota Bar book. It deals with the limitation of our process in dealing with judges up until nearly the turn of the century, and that is the only way a judge could be disciplined prior to the adoption of the code and the rules was by a constitutional limitation of impeachment. And the only case Minnesota has had in that experience was a man by the name of Julian Cox, who back in 1883 was charged with drunkenness, visiting a house of ill repute, and there was a 4-month trial. There were articles of impeachment were sent to the Senate, and the Senate held a hearing which lasted, as I said, 4 months. There were 160 witnesses, 1,700 pages of testimony, and Julian Cox was impeached. Now, the reason that's significant is it shows how cumbersome the impeachment process is, and why around the turn of the century, from the late 1890s up until the 20s, people were looking around for another way of handling judge discipline. The interesting thing about Judge Cox was that he went to the legislature and they expunged the impeachment. And so Minnesota technically stands, we've never had a conviction of any kind under the impeachment statute. So in the 20s, ethical standards were a significant factor. The American Bar Association and other agencies were working on a simpler method of dealing with ethics and judges. In 1924, there were ethical guidelines issued by the American Bar Association, and also, but it did not contain any basis for discipline. In 1944, the Minnesota Supreme Court adopted, set up a judicial council, which became worked on a study by Maynard Persig. Some of you who are my age might remember that name. He was a very popular professor at the University of Minnesota. And he determined that there was no judicial reason or rule reason that the Supreme Court could not make rules dealing with the question of judicial ethics. And that was in 44. Nothing really happened, though. There was a proposed bill in the study, but it never went anywhere. By the 1970s, however, 22 states had adopted constitutional amendments to provide for the agency review of judicial conduct and to provide for discipline. No state had adopted by the legislature a code of conduct. There is no state has adopted, or no legislature has adopted that in this country, at least according to the American Judicature Society. Not letting this activity with the Bar Association die without action in 1968, Chief Judge Knudsen made a suggestion with the district judges that really we should do something to establish some general standards for judge conduct. And the chief judge issued an order on his own, appointing a commission on judicial responsibility to deal with that. And the purpose was done in February 1970, and the chief justice's order created a commission on judicial responsibility, which would counsel and advise all judges of the state with respect to their conduct, participation in non-judicial activities. This was all voluntary on the part of the Judiciary in Minnesota. However, there's no provision for discipline. It was just guidelines. In 1971, the Constitution adopted rules to investigate and hearing before the commission. In March of 1972, the Supreme Court adopted a code for judicial conduct based on the American Bar Association Model Code. At the same time, the legislature created a commission on judicial standards, and the rules were to be made by the Supreme Court. Now, this required an amendment to the state constitution because there was no provision in the Constitution for disciplining judges or removing them. So as a result of the activities of the Bar Association and the Supreme Court adopting the code on judicial conduct and the rules, there was an amendment to the Constitution which provided for a state agency funded by the legislature, rules made by the Minnesota Supreme Court. This is all controlled by a 10-person board, and the governor appoints all of the members of the board except the judiciary, judge, or the lawyers. Now, most recently, there was an amendment to the model code of the American Bar Association. So in 2007, in a 3.5-year process, the entire code was reviewed, promulgated a new code after 3.5 years of work. The committee was comprised of judges, lawyers, academicians, public members, and even more recently, the ABA model was again studied by the Bar Association 2 years ago and adopted extensive hearings. The Supreme Court held public hearings and received comments with very little objection from in other words, the public comment when the hearings were held around the state and in the Supreme Court, and there was very little input adverse to the action taken. So to be a little repetitive, that what we have at this time is, as I said, a state agency, which is the Board of Judicial Standards, is funded by the legislature. It provides specifically that the rules will be made by the Supreme Court, which has been done. The board is, which controls the conduct of the membership of the board, is a 10-person. They have, someone mentioned it earlier, 2 lawyers, 4 public members, and 4 judges. And all the persons are appointed by the governor except the judges or the judicial personnel. So that's how we got to where we are today. That's the history.
I'm going to give you again my perspective as an attorney who's practiced law for over 30 years. I have filed ethical complaints against judges with the Board on Judicial Standards. I might just as well have thrown them in the wastebasket. It's like it's a black hole in which complaints seem to go into and in which you never really seem to get a response. All of their hearings are, the public is excluded, including even the complainant. So you have no idea what they're doing, what their decisions are, what the outcome is, and most surprisingly, I guess, was the fact that I would file complaints and never be asked a follow-up question, never be asked to come and testify, never be asked for why I said what I said in my complaint. Just amazing. Another problem with the way this is set up is the influence of the Minnesota Supreme Court. And I want you to understand this process a little bit better. And you need to look at Article 6 of the Minnesota Constitution, Section 9, which deals with retirement, removal, and discipline. It in part says the legislature may also provide for the retirement, removal, or other discipline of any judge who is disabled, incompetent, or guilty of conduct prejudicial to the administration of justice. No other branch of government, including the Minnesota Supreme Court, has that delegation of power. Only the legislature has been given the power to remove or discipline a judge. Now, the first thing you did in furtherance of that constitutional provision was you enacted Minnesota Statute 490A, which set up the Board on Judicial Standards. And if you look at that bill or that language as it now stands and go to the last provision of the current language, which is, I believe, subdivision 7, it says the Minnesota Supreme Court will make rules to implement this section, and That's how the Minnesota Supreme Court got the authority to issue the Code on Judicial Conduct. Now, the only problem is that what you've done is literally put the foxes in charge of the hen house, and they've mucked it up.
I had a question, Judge. You had made a comment referring to the legislature moving away from a reliance on an impeachment authority or the legislature moving away from an impeachment of a judge authority and adopting a judicial standard board. And the reason that you had mentioned was that the impeachment process was cumbersome. Could you extrapolate on the cumbersome nature of an impeachment?
Probably more in the context of when it occurred in 1883 than it would be today. But it was simply the mass of effort taken by a legislative body that certainly had a lot of other legislative problems on their table, and the amount of time and effort was spent on this particular disciplinary problem. I hope that clarifies what I meant by my statement.
All right. 1883, that's...
I'll give you 1883.
Thank you. Senator Thompson.
Thank you, Mr. Chairman. I really have more of a couple of comments than a question. The legislature has completely abdicated its authority in the oversight of judges. By handing off the responsibility to standards boards, to other people, to folks that are within the system, has virtually assured the fact that there won't be proper policing of the judiciary. And the legislature ought to collectively be ashamed of that. If judges truly make a comment from the bench that they're ignoring the law and going with their feelings, they ought to be dragged in front of this committee and asked about it. And unfortunately, I don't think that happens because obviously that's not very politically popular. Of course, the judiciary is not without fault either. The judiciary has taken on a much more significant role in our society than it should have through asserting itself overly aggressively in the area of judicial review and other things that called to mind the Federalist 78, which I hadn't read for a long time, but I went back and found this quote that I think will make people understand the difference in the view that our founding fathers had of the role of the judiciary in comparison to what we see them do today, as there are marches on our Supreme Court rather than our legislatures to change the law. This from the Federalist 78. The judiciary, on the contrary, has no influence over either the sword or the purse, no direction either of the strength or of the wealth of society, and can take no active resolution whatever. It may truly be said to have neither force nor will, but merely judgment, and must ultimately depend upon the aid of the executive arm for the efficacy of its judgments. So the problem we have here is judges are too significant, which is why how we select them and how we discipline them and how we review their performance has become far more important than it ought to be. And until the judiciary is willing to see its role as less significant in our society, and until legislatures are willing to do the politically difficult thing and ask judges about the decisions that they make, we'll never solve the problem.
Mr. Chair, and members on that issue, Senator Thompson makes a great point, and that specifically to the judiciary has no control over the purse. And we've seen in the state of Minnesota itself where when we can't come to a resolution on our budget, the judiciary grabs the purse and starts telling people what should be spent and what should not be spent, which has never, never, never been the role of the judiciary in this society, in this country. That is wrong, wrong, wrong.
I'm just encouraged by the debate that we're having about the, balance of powers and the three branches of government. It's not surprising that a legislative branch would want to question the power of the other branches. And so I think it's good that we have a discussion about what our role is, what the judicial role is, and what the executive branch role is. And so I just point that out, that it is important to have that, but I think it's not surprising that we might question, what their power is, but we need to be careful that we respect that there are three branches of government and that they each have their own role.
Good point.
Chairman McGuire, it's always good to go back to our job description as it was originally written. See what our job was. Senator Thompson.
Thank you, Mr. Chairman. To Senator McGuire's point, I certainly don't lack respect for the judiciary. I'm a licensed attorney, have been for 24 years, and have done a lot of litigation, been in front of numerous Article III judges as well as administrative law judges. So that being said, I respect the people more than I respect any branch of the government, and the people deserve to have government administered in the way that our Constitution sets forth. That's my concern. I have really no bias against the judiciary or the legislature, and I've even been nice to the governor today, so I'm really being a good guy.